I'm indebted to it.
Sorry, Chair, I just want to establish if Mr. Behari got his document back from the attorneys.
Yes, I have.
Okay, thank you.
Yes, Mr. Segeels-Ncube.
Chair, if we may hand up the A13 statement of Brigadier Mkwanazi, which formed part of the IPID docket, which was provided to us by Mr. Behari. We will do the pagination and all the necessary after. Thank you, Chair. And I would propose that we put it in the supplementary bundle as the last document. Yes, Mr. Behari.
Thank you, Chair. We were at the part where we state that your report attaches little or no value to the statement of Director Mkwanazi. Chair, the document then that we considered was in the IPID report itself, and not the one on page 88. When we looked at the report itself, not the one on page 88, which is a letter from J.D. Mkwanazi to the Chief of Police. The document is titled, it's basically the warning statement, Boxburg case number 26203 of 2023, obtained as at, was signed the 21 July 2023, Chair. And Chair, the considerations why we asked, because in that IPID report, we asked him to look at attaches little or no value. So we could not see any reference to the sworn affidavit by Mkwanazi. And the content of that sworn affidavit, if I go through paragraph 4 of that, Chair, which talks about his appointment by Deputy Chief of Police Mzolo. 5, when he assumed he's acting in the said post, he was given certain tasks, and then he correlates that to the tasks being on, I'm not sure what page, but the document to-do list dated 15th of October 2021. In that document, on the last, so if it's a copy from mine, there would have been highlighted parts as well in that document. It's due date for SOP from Security Division and all, 20 October 2021. Reports mentioned there. So that is why it was really considered that. And furthermore, the report doesn't talk to, in line, see the to-do list marked Annexure 2. So these were to-do lists given to him by Mzolo, and for him to continue to finalize that. And in that to-do list, I think 4.10 or 5.10, it says finalize standard operating procedure on Security Division by 20. So then it goes to the EC memorandums marked number 3. Memorandums I wrote as part of the administrative duties. I included a memorandum dated 18 October 2021, which served to confirm working relations between EMPD Specialized and a company called CAT VIP Protection. Working relations were within the powers of the Deputy Chief of Police under that operation. So working relations were confirmed in my capacity as an acting chief consist to exist until today.
Please refer to paragraph numbers so that we follow where you are reading.
Paragraph.
I do see it's paragraph 8 that you just started.
Yeah, paragraph 7, and then it goes on to paragraph 8. Yeah?
Yes.
Then 2022 operational plan. So at that stage, it says plan with the tasks designated for VIP and CAT VIP. Subsequently, we've heard that the operational plan was evidence to that to say it was a forged document, but this was a document considered by Mkwanazi in a statement to IPID, which talks to the working relations between EMPD Specialized Services and CAT VIP. Protection came at no cost to the municipality, and as such, partnership would help to the CAT VIP protection to earn recognition in the security industry to members of the public, thus build profile. And then on the next page, paragraph 10, subsequent to the confirmation letter, 1810, due to shortage of operational cars. So that's basically what's contained in the other report as well. As an acting Deputy Chief of Police, I approached CAT VIP to seek an assistance in the form of donation of cars. The response from CAT VIP was positive, after which a memorandum of understanding was proposed. And then the CAT VIP would donate 4 vehicles, and that, of course, that's a repetition of what's contained in the other document. Then there's an email from Goodman and Zolo to Julius with the to-do list attached. So these are the documents we consider, Chair, when we look at what, because in the IPID report itself, we did not look at any way referred to this document, which was part of the annexure, which was part of the interview process. It returned that whether this was taken into account, whether he had done any further investigation from there, did they discount what he said, in that regard. So that is what the line of thinking was when we said, your report attaches little or no value to the statement of Director Makonazi on the suspect in this document here. Then we went on here, I'm going back to annex page 87.
Mr. Behari,
yes,
can I stop you?
Yes, sir.
You made us adjourn for 30 minutes, and Chair made it clear to you when we adjourned that the purpose of you looking at this document was to show us where it says what you say. I mean, the sum total of this document is that the MOU was never finalized. That's what he says in para 12. And then that MOU is attached as one of the documents and it's unsigned. That's all this says.
Yeah. When we started dealing with the matter and we came to this part here, I was referred to page 88, which was a letter in another matter, or in the other issue, concerning the working relations with CAT VIP. So we're coming to now the IPID reports and the letter that was drafted with regard to looking at the so-called concern areas in the IPID report. Hence, I'm saying I wanted to see this to say what it says. And why was our thinking behind the fact that we say that you attach little or no value to Director Makonazi's report or response. And that is why we looked at it, Chair. And I know, my apologies if it's deemed to be wasted, but for me, I needed to see it. Clearly a document which the Commission had not, looked at or possibly had, maybe looked at but not had, which has resulted in me looking at this document. I think it's important for that respect. Because this document, linked to the IPID report, gives us then what the thought process was in completing the rest of the document.
You see, the point of substance is that page 345 on your letter, and I say your because you basically approved the content. First line, you make the point, and Ms. we referred to this. You make the point that it will be difficult to prove fraud and corruption. Your report attaches little or no value to the statement of Director Makonazi, the suspect. How does what you have just read now, how does it show us that it will be difficult to prove fraud or corruption, if at all?
Okay. In terms of fraud, we dealt with the elements of fraud in this document.
No, what you have read, how does it?
From what I've read is that the Makonazi, he was saying that he was responding to or furthering the functions or the duties given to him by the Deputy Chief of Police in Zolo. In doing that, he proceeded in this regard to say, when I assume my acting responsibilities, he had to finalize, one of the issues he had to finalize at 5.10 was finalize the standing operating procedure on security division by the 28th of October. He then says that in line with the administrative tasks, executed my duties and designed the SOP and wrote memorandums connected to security division documents, which were all escalated to the office.
We saw you and we saw that and we heard you read it. I'm asking you a simple question. How does it make it difficult to prove fraud or corruption?
Yeah, holistically, from the IPID report read together with this document, and where we say you haven't considered what he's saying here in terms of the fraud and corruption, where was the the elements are crafted here. So the document is essential to say that when we say you haven't considered it, in here, Mkhwanazi sets out a position, which we looked at to say, but if you not looked at here without verifying what his position is, and what he says that he was acting on instructions or acting in furtherance of another matter, then that should have been also investigated further to complete your full report. So that is part of the issue. We looked at the evidence, hence the definitions to the extent of fraud and corruption linked to fraud and then in terms of practice.
I will suggest to you that that document has nothing that shows that it will be difficult to prove fraud or corruption. There's nothing in that document that shows that. And that is why it's difficult for you to pinpoint for us where the difficulty appears or manifests.
So, on page 87, the difficulty to prove fraud and corruption, I've consulted with internal staff and I'm advised on the current evidence, it will be difficult. And holistically, one of the first aspects is your report attaches no value to the statement. So that report or the statement was never discussed. Holistically, it would have been difficult to prove fraud and corruption, given all the other factors that we've listed here. And it goes specifically to, if you look at in respect of fraud, what are the issues we raise? On page 3, in respect of corruption, what are the issues we raise? So this is why in total, given the 4 factors we've raised there, and also including the fact of non-consideration of this or not dealing with this, we raise that it could be difficult to prove fraud and corruption, and hence that is at the time, the undertaking considered was what we came to see.
Ms. Segeels, you are still dealing with the letter that let me come.
Thank you, Chair. Mr. Behari, the next aspect on the letter relates to the issue about the benefit. I think it's on paragraph 5 of page 345. Where you deal with the registration of the vehicles was not done by the suspect, but by the authorized personnel from Fleet. You see that? I think you've dealt with that aspect with Chair. But later on, you deal with the fact that at paragraph 8, you say on page 346 that the fraudulently registered vehicles using the city's funds amounted to corruption because CAT benefited unduly. This is not true. The vehicles were not registered fraudulently, as you've said. It is difficult to see how CAT benefited from the registration of the vehicles as they transferred ownership of their vehicles to the city. On the contrary, CAT sustained a loss of the asset while the vehicles were registered in the name of the city. Now, when you take that compared to what Brigadier Mkhwanazi says in his statement, which you were referred to by Commissioner Kumar in paragraph 12 of his warning statement, where he says the donation of cars, memorandum of understanding and delivery of vehicles was not finalized as a result of the dissatisfaction by the department, EMPD. If it says that the delivery of the vehicles and the donation of the cars were not yet finalized, it means that CAT was in possession of vehicles registered in the name of EMPD.
The flow in terms of that part was that the vehicles were registered. They went to Christine had given when the details of the vehicles were brought through. They were registered by Christine and his delegate or other officials involved in that. And thereafter, Rivers Peace, Deputy Commissioner Rivers Peace raised and said, no, these are not proper in terms of the donations. They went back, and that is when, I think within a day or two, they registered back to CAT PRP. So in terms of delivery, all the intention was, in terms of the donation that was effected, was put in place for receiving those the 4 vehicles. The only issue then was, of course, the important issue was the Rivers Peace raised us and said, no, the donations are not following the process, hence they were returned. And that is where, this is our understanding from what's contained in the document.
Sorry, why do you say they were returned? What was returned?
The vehicles, when I say returned in terms of ownership vehicles, so...
No, Mr. Behari, you are a lawyer. You know how movable property is transferred in law. If Mkhwanazi has never seen the vehicles, and EMPD or Ekurhuleni was never in physical possession of the vehicles, why do you say they were given to Ekurhuleni and then they were returned? They were never given to Ekurhuleni. What happened was that registration documents were completed and the cars were registered in the name of Ekurhuleni.
Yes.
But there was never delivery of any vehicles. And those vehicles remained in possession of CAT VIP. That's the factual position.
Chair, I never said that there was physical delivery of those vehicles. I said that changes were given because Mkhwanazi gave the details to Stain. He registered the vehicles. When I talk about return, I mean return of ownership, not the physical vehicles. That means they went back and they re-registered the vehicles again out of the names of Sitya Ekurhuleni back to the donor. That's such. So there was never any time where I suggested that the vehicles were physically came to Ekurhuleni.
What was the benefit for Ekurhuleni during that time? Between the date when they were registered in the name of Ekurhuleni and when they were registered back to CAT, what was the benefit of Ekurhuleni?
There was no exact benefit at that time, but if you look at the entire intention of the process was for the vehicles, Ekurhuleni to receive 4 vehicles. It was just a donation. Once the issues were raised and said this is not an acceptable process, had that not been finalized, it would have been a benefit.
So the benefit is the intention.
The benefit in terms of what was going to happen, had that finalized, the process finalized and the deliveries, there would have been the benefit to the
But when you prepare this memorandum, you know that the process was never finalized. So you can't look forward and say, had it been finalized, you know that it was not finalized when you are doing this response to IT.
But it goes to the intention of donating the vehicle. That's covered everywhere else.
No, the intention does not matter, Mr. Behari. When you prepare this report, you know that that never happened. Whatever the intention was, it never materialized. You know that.
Here, the vehicles were transferred in the document, transferred. So transfer of ownership happened. And then transfer out of ownership happened. The delivery itself would have been perfecting and finalizing the process. That never happened.
Thank you, Chair. Chair, I have no further questions on this document.
Can I just ask, this sworn statement, at paragraph 5, it lists the functions that Mr. Brigadier Mkhwanazi says where he was tasked, administrative tasks. That's what he calls it. Which of these do you, and they range from 5.1 to 5.12, which of these did you consider to authorize him to do this transaction of accepting donations, of entering into MOUs with Medicare and CAT VIP?
There is no one instance to say to him, giving you any authority to authorize. That in any fact, if there was such an authority, there would have been...
I can't hear you properly. Yeah. Maybe just move forward a bit.
Yeah, so I'm saying that in terms of the provisions there was nothing authorizing him in terms of the functions given to him.
Yes.
But overall, the functions were to seem to finalize standard operating procedure on the security division by October 2021. Now, in that standard operating procedures, finalized standard operating consolidation of comments. So all of these functions here was what he used to continue to say, I'm finishing the orders. So hence I'm saying it should have been explored by IPID to say, what exactly were your functions?
No,
what exactly
you explored it. That's why you're commenting that he's not guilty. It will be difficult to prove fraud and corruption. It's because you have looked at this. You actually tell IPID that he was authorized. He had certain authority from his superior who was on leave, and he acted in accordance with that. So this is what you say at 3. You say there is unchallenged evidence that the suspect, while acting as Deputy Chief of Police, was given powers by Deputy Chief Mzolo to finalize matters relating to the security division. And then in the last sentence, you say the suspect was duly appointed to the acting position and was empowered to attend to matters relating to the security division. The report does not elaborate on this. And then you say, so if I get to the Christine matter, now I look at this list of tasks which Brigadier Mkhwanazi describes as administrative tasks, and I think he's right when you look at that list. All of it looks administrative. Which do you say authorized him to do the things that are the subject of the complaint and the investigation by IPID? And it's not, let me offer, it's not standard operating procedures to accept donations, to instruct Christine to register those vehicles, to send MOUs, to consider an MOU and send it to the Chief of Police for his signature. That's not standard operating procedures. It doesn't fall under 5.10. And what else in that long list of tasks authorized him to do? Did you consider, when you did this letter and challenged IPID, what did you consider to fall within the mandate that he did?
We asked IPID, did he consider what he said in total? If you look at paragraph 6, in line with Administrative Task 4.0, I executed my administrative duties and designed the SOP and wrote memorandums connected to the security division.
So when you say paragraph 6, you mean of the...
Of that annexure that we just attached now, we received now. On paragraph 6 of that, after the administrative functions are listed.
Okay.
And wrote memorandums connected to the security division, documents which were all escalated to the Office of the Chief of Police and relevant external stakeholders. Yeah. So if you look at that, and you look at the other evidence there, if it involves the memorandum that we've been dealing with all of this, which you would say was not legally compliant, not approved by the chief, but it was sent to the Office of the Chief of Police, and hence I'm saying it should have investigated based on what legal tires mentions. That.
But investigate what? Because the memorandum that he relied on is unsigned, and he says so. So what did you want IPID? What are you criticizing IPID for?
Yeah, he says here that he was entitled to by way of his acting appointment.
And you accepted that, right, that this list from 5.1 to 5.12 authorized him to accept donations.
But to do all in terms of then he qualifies it.
No, Mr. Behari, please try and answer my question. I'm asking a direct question. So I want to know, do you say, and please point me to what it is. I'm saying look at 5.1 to 5.12. Do you say anything in that list of 12 tasks empowered him or authorized him to accept a donation of motor vehicles and to get it registered in the name of the EMPD while those motor vehicles remained with CAT VIP, because that's what happened. We know that's what happened.
Sure.
Are you saying 5.1 to 5.12 authorized him to do that? And which of these tasks do you say authorized that?
Sure. 5.1, if you look at paragraph 6, which talks holistically in his affidavit, in line with the administrative task 4.10, which is Annexure 2, I executed my, now the Annexure 2 talks about doing well, here it's listed as from 5.1 to 5.12. It refers to 4.10. I executed my administrative duties and designed the SOP and wrote memorandums. So I would expect that they didn't deal with that in that report.
No, forget IPID did not deal with it. You are looking at IPID's report. You write this response to IPID. So you're engaging IPID. You've looked at Brigadier Mkhwanazi's warning statement. You satisfied yourself that what he did falls within the tasks that are listed in there. Otherwise, you wouldn't say what you're saying in the statement. You wouldn't say to them, fraud would be difficult to prove. right? You wouldn't be saying that. You wouldn't be saying corruption would be difficult to prove unless you have engaged with it and formed a view. And that's the discussion I'm having with you. I'm testing you because remember, as the chair told you yesterday, the background to this engagement with you is you colluded with the CEOs, with the city managers' protection of Brigadier Mkhwanazi, who evidence before us is he was involved in a relationship, an inappropriate relationship with Mr. Madlanga and Mr. Madlanga's company. That's the context in which we are having this discussion with you. So you have to be able before us to explain your own positions where things don't make sense. It doesn't make sense, to me at least, that you would look at IPID's letter to the city, which directs you to take disciplinary action, and then you would respond in this long letter, engaging them about proving fraud, the difficulty of proving fraud and corruption, and setting out what the difficulties are with it. It doesn't make sense that you responded that way. So I would like to know from you, the head of legal, when you wrote this response to IPID, what did you see as exculpating Brigadier Mkhwanazi in his warning statement, not what he says? You see the list of tasks, you see paragraph 6, where he says, in line with administrative task item 4.10, which is to finalize the standard operating procedures, I executed my administrative duties and designed the SOP and wrote MOUs connected to the security division, full stop. Rather, documents which were all escalated to the Office of the Chief of Police and relevant external stakeholders. That paragraph, when you read it in this warning statement and when you looked at the tasks, what did you consider to be exculpatory of Brigadier Mkhwanazi that would make the corruption claim and fraud claim difficult to prove?
The exculpatory part, Chair, would have been then where in paragraph 6, where he says that the functions allocated to him in terms of 4.10 Annexure 2, he executed his admin functions and designed an SOP and wrote memorandums connected to the security division. Documents which were all escalated to the Office of the Chief of Police.
Okay, so you're saying he's writing the memorandum and escalating it to the Chief of Police was an answer, according to you, to a charge of fraud and corruption.
It's part of the process where he says that I was authorized to do this. I was authorized to do this by my Deputy Chief of Police, and I was following up on those instructions.
Okay, and you accepted that he was authorized to receive a donation? Because you say, that's what he says, right? So I'm not debating with you what he says. I'm saying he says this in the statement. You accept that he was authorized to accept a donation because that's what the complaint is.
The authorization, which I spoke to, was about him drafting the MOUs and sending them to the Chief of Police. Yeah, I want to complete that train of thought. Sending to the Office of the Chief of Police, who ought to have commented and say, but this is not what is on and this is what is not what he said. So when he states here, it should have been further delved by IPID to say, but what do you mean you have this authority to do that and you send it to the Chief of Police? Then the Chief of Police be approached for that. Other external stakeholders we know would have been Medicare 24 in terms of the trail of emails we've looked at. But I'm saying that in terms of that, did you look at the affidavit of Mkhwanazi? Did you consider that? Because he's creating the impression here that he was authorized to fulfill and complete investigations and also inform the Chief of Police to that extent.
Thank you, Commissioners. Chair, I indicated that I had no further questions on that letter. May I proceed to the next issue? Mr. Behari, I want to deal with the issue about the change in the delegation matrix, which you deal with on page 9 of your statement, starting at paragraph 37.
Yes.
And we did deal with it to some extent. It is in relation to the 22 August 2023 directive from the city manager, you recall?
Apologies. Whilst I was looking for the statement, I did not hear the page and paragraph.
It's page 9, paragraph 37, Chair.
Thank you.
Recall that we dealt with that, and in particular paragraph 41 on page 11. The 22 August 2023 delegation issue.
Yes.
Now, you don't really give background as to how this delegation matrix came about. Do you recall what transpired just before the directive from the city manager?
Yeah, the only issue that I know that was major, I was informed of, I was not part of, there was a meeting between the city manager and the EMPD senior management and staff to address issues that were raised by several employees in that. Thereafter, I think that was on the, if I look at, I think it's the River Species, the Deputy Commissioner River Species bundle. It was where he attaches the CM meeting EMPD management. That's the only issue, because that was, seems to be the one why the city manager then decided to relook those delegations. But there was also an issue where Mr. Gneza had raised, well, I think it was subsequent to this, that he was given the delegations by Mojapelo. But I think this was a document, I believe, to have been the catalyst in trying to get to do the letter of the 22 August 2023.
If you go to Mr. Ngiza's statement, but he deals with it quite comprehensively, what led up to that according to him, page 24. And Commissioner Kumalo touched on it, I think yesterday. It's the big issue.
Is it page?
Page 24, paragraph 74 of Mr. Ngiza's statement.
Page 24, paragraph 7.
Yes. Page 24, paragraph 74. Do you have it?
Yes,
Anonymous emails.
I have it.
Okay. And you see he refers to a date of the 20th of August 2023 when the first email was received from bigty852@yahoo.com. And the email was sent to Jeff Wicks and Ms. Kasheka, Dr. Mashazi, Deputy Commissioner Space, Chief Mapieye, and yourself were copied in on it with the subject line favoritism, corruption. And the contents of the email was effectively that there is a clique that is protecting Julius Mkwanazi in respect of disciplinary proceedings, which are the disciplinary proceedings we've been dealing with. Do you recall those emails?
I do recall the BXPX email.
Okay. Then at paragraph 78 of his statement on page 25, he says he saw the email on the morning of the 21st of August 2023. He called Chief Mapieye, who indicated that he had not seen the email as yet. And he says, I did not respond and did not have an opportunity to properly consider the email because I was a witness in a labor dispute scheduled to be heard in Benoni that morning. At 79, he says, that very morning I received a call from Ms. Kasheka instructing me to drop everything and to immediately get to the office of the city manager. He says he pleaded with the arbitrator to release him. And at paragraph 80, he says, on his way to the city manager's office, I received a call from Mr. Titi Majang, of Madlanga attorneys, and he informed me that he had received a call from Advocate Kemi Behari demanding that he gets to the city offices immediately. He refused because it was a last-minute demand and he already had other commitments. At 26, paragraph 81, Mr. Majang shared with me that from his discussion with Mr. Kemi Behari, he gleaned that they suspected a leak of Brigadier Mkwanazi's charge sheet. Mr. Majang was upset because city management had stopped the disciplinary proceedings against Brigadier Mkwanazi without an explanation to him, and yet they were now demanding that he drop everything and come see him. Then he says he went to Germiston and went to Dr. Mashazi's boardroom where Mr. Kasheka, Dr. Mashazi, and yourself were all present. And he then says Dr. Mashazi asked him if he knew Dikki Bikti, and he denied. And so you would have read what he says about that version. The important aspect of that is the email is sent on the 20th of August. There's a meeting on the 21st of August. He gets summons to this meeting. He is the HR specialist, correct?
He's correct.
The division
head, employee relations, yes.
Yes. And on the 22nd, a delegation matrix directive is issued by Dr. Mashazi, which effectively transfers all his powers insofar as disciplining employees are concerned over to you. Now, in light of that factual matrix that he sets out, what is your version on how this directive came about? It seems very compelling that it was all designed to protect Brigadier Mkwanazi.
Okay. To look at the directive of the 22nd of August, and I've stated again, in no way did it take any powers from anybody, even the HOD or elsewhere. It was an added leg in terms of where we looked at, and it goes back to the HR to continue with the functions. So in no way did that directive, it actually gave me more of a burden in terms of now going back and doing a consideration of, does it need to go for further investigation? Does it need to go for an internal department, or to recommend to the external tribunal? There were factors, in fact, from the 17th that have been going on. There was, together with the meeting with the EMPD, if this was one of the factors went on, I recall the meeting on the BXBX email. There were several concerns. I did call Mr. Majang, but not in the manner the way it's put here. I did call Mr. Majang and said we have concerns because the charge sheets, which CM didn't succeed, or the HR didn't, and she's been trying to get the charges. We have concerns that these charges were now leaked, or there was a leak in the BX email, which deals with all of the issues up to the attempted service of the charge. If you look at the full content of the BX email. So I had no problem with that respect, because I had to, as a deputy information officer, raise those concerns when the BX email came through, and we did follow up on that. Now, if he's aligning that aspect to removal of any functions, there was no removal. If you look at the exact letter, Chair, there was no removal of any functions or anything for him. He just created an added leg of my involvement from a compliance perspective as to what was required. And I think, yeah, as I was going along further, if I may, it is just wanted for us to give full disclosure and treat all the employees, especially at the EMPD. If I looked at the EMPD complaints as well, Mr. Niza's name was mentioned in that EMPD complaints as well. So there were complaints brought by various, so you can see clearly at the EMPD meeting, there was a crisis that was involved with the senior management. So all of this issue in total would have contributed, not necessarily the standalone issue of the BXPX email. And in any event, I wasn't given the overall responsibility to decide anything on disciplinaries. That was never the content as I understood it in the letter.
In the context with which you understood it, in the context with which you understood the new delegation matrix, you say that you didn't have those powers.
I never had the powers to take over any disciplinary proceedings. The only added leg was there to ensure an added leg of compliance was to consider what is the evidence available up to even the 1st of July, the 1st of December. I was performing that part as well.
Can you go to that new delegation? It's PN 13 in Mr. Ngqiza's statement, page 311 in his annexes.
Yes, Chair.
Before we actually deal with the document, can you tell us what was your involvement in the drafting of this document?
I did not draft the document. I was not involved in the drafting. The concerns city manager raised was stemming from the issues at ENPD, which seems to have culminated in this process. So the BX emails came in between that, and that then added a further ground to say, but how is the possible leakage of information at the city? And there's been a lot of leakage in most of the departments, where we're having then emails that you cannot link, or very difficult to trace in terms of who has been dealing with the defamatory material or what other leakage of information, personal information, and so on. So that is where the concern came from the city manager. So it's in the cumulative part, from starting off on the 17th with the meeting, and then I was informed about the meeting, and thereafter the issue of the BX email came out, and then city manager came up with this. So I had a discussion in terms of, I was briefed that this was going to be happening, but I was never part in drafting this document itself.
Okay, but so you were informed that you would have added responsibilities before the document was communicated to the rest of the team?
Yes, I was informed that I have to add in terms of looking at the evidence issues and so on, and do we sustain a possibility of successful HR matters or any other disciplinaries in all departments. And that is only because of the high expenditure being spent on labor matters, and especially lost disciplinary proceedings, lost arbitration proceedings. So that was a measure by this accounting officer to try and stifle that and hold it, to say we need an added leg before we even go out there to look at what is the evidence, is there further evidence required, and then, or is it at this stage after the by the department's investigation, do we need further evidence? Can we go on with the department to do its own internal, depending on the seriousness of the allegations, or can we go for a disciplinary tribunal? I would recommend then to the HOD to say, I think at this stage we have sufficient evidence to go on with the disciplinary tribunal.
Mr. Behari, you say that the reason for this is because of the high number and the expense of labor matters.
Yeah, apart from the high number, basically the labor department, there were a high number of lost cases at arbitrations, any other forum. Even the labor courts, we had to recently try and stem because of more detailed investigation into that. But there was a high turnover of lost cases. And then there was also the allegations from the EMPD officers. There was, as you can see, the clicks. It'll tell you in the minutes as well how, and that from the accounting officer position, even in terms of the functions it performs in terms of the SAPS Act, it was important that she gets into it. The BX emails came in thereafter, because in the discussion with the CM and the HOD, it was there's a whole lot of information or processes that are happening, which is not, it is exposing and possibly ineffectiveness of the EMPD.
Okay. Now, if you look at page 312 of that document, and there are 2 bullet points at the top, and then there's next full paragraph. I would like you to look at the paragraph that starts to usher in. This is where the city manager provides her reasons for this procedure. Can you just read that and then explain how it reconciles with what you say about the reasons for this development?
To usher in expeditious, credible, consistent and uniform management of discipline within the municipality. The following persons are hereby delegated to perform the above listed functions, as well as other functions connected therewith, as appears from the collective agreement, in that regarding to the municipality, city manager's authorized representative.
Yes. And your explanation for why this change is brought about, how does it reconcile with what you've just read there?
So my explanation is there was a cumulative proceedings that led or started off at a meeting 17th of August 2023, which was about 3 days before this. And in that document, in that meeting, which is, I'm looking at the recording or the minutes minuted by Mr. Spies, but there was a clear indication of a disjoint between factional parties in the EMPD. Now, that is where she looks and says, and I suggest to usher in expeditious, that means faster proceedings.
Yes.
Credible, consistent. Those credibility and consistency comes from the allegations made by EMPD officers in that other document.
So it has nothing to do with you were losing a lot of labor matters.
Yeah.
That's what I want to establish, that this paragraph doesn't say, I mean, she wrote quite a long letter, and nowhere does she provide the reason that you are providing for this change. She speaks about expeditious, which I accept its efficiency. It speaks to efficiency. Credible, consistent. It has nothing to do with the big number of matters that the MPD was losing. Doesn't speak to that. And then uniform management of discipline.
So these are terms used in the broader aspect. If you look at credibility and consistency, but because of there being in the past, they have not been credible.
Can we agree consistency? You can talk about credibility. Can we agree that consistency has nothing to do with it's not a reflection?
No.
Maybe let me say it differently. There's no reflection whatsoever on losses that EMPD is suffering in the bargaining council.
Sure, we can't agree on that.
Why?
Because it's consistency of the way labor matters are dealt with and linked to credibility. In some matters, and the loss of that was because of several reasons I've been picking up. Sometimes the investigations were not done properly. There were witnesses who were supposed to have been coming through to give evidence at the last minute would pull out to intimidation.
That's not a consistency issue.
See, it is a consistency in respect of what we uncovered at the meeting.
No, it's not a consistency issue. You lose matters not because you're not consistent. You lose because you have a poor case. What you're explaining is preparation, witnesses not appearing. Yes, you will lose cases for that reason, but that's not consistency. Not a consistency issue.
There's no consistency in the quality of the work done. And there have been matters which I've come across where deliberately processes were not followed to allow the employee to come back. So there's no consistency in the quality and the processing of this information. That has led to the weaknesses that have pulled up and a lot.
I accept that explanation.
Thank you, Chief.
Yes.
Then to go back and I say it's very important that the content of, so for me, I was informed after the meeting of the 17th by HOD Linda and city manager to say there are serious concerns at the EMPD. We need to look at that. We need to address the matter because Mr. Niza's name was also brought in as being part of a faction at the EMPD with Spies and Chief of Police Mapiyeye. And the environment was toxic. I think we've had sight of it. We should have had sight of it, if not. But that is all of the issues which the accounting officer and responsibility with the SAPS Act. That is what the engagements continued. The BX emails came in between or thereafter.
No, I'm not talking about the BX emails. That's a discussion between you and Ms. Ncube. All I wanted to understand is your explanation for why this came about. and what she says, what she gives, what the city manager gave as a reason. I wanted you to just reconcile those.
Yes.
And I'm moving away.
You're moving away.
Yes.
No, thank you, Chief.
Thank you, Commissioner Baloy. Now, Mr. Behari, if you look at the where Commissioner Baloy had left off on page 312 after the paragraph that says ushered, and you look at the steps that the city manager has now said this is the new process that will be followed. A2 refers to requests for allegations to be investigated must be submitted to HOD corporate legal upon determination of a prima facie case cause for HOD corporate legal services to confirm the allegations, consider the evidentiary matter, and submit a report to HOD Human Resources. You would agree with me there that Mr. Ngiza, as the divisional head, is excluded from this process?
I just want to be HOD, HR, and I had a discussion after that. There was not a request for allegations to be investigated. They are investigated in the departments. That's where the prima facie case is established. Yes, the document states that. But in effect, what was brought in was my role, which I discussed with the HOD, was only to receive matters and the NCC, even the practice since then, is that I don't request for allegations to be investigated. Must be, that is not for the investigation. It comes from the HODs. If there is an investigation that comes through, then we will look at that. But we look at the prima facie evidence. Request for allegations and must be submitted to HOD corporate legal. Yes, I have been called in terms of the added leg of compliance to say, what are you looking at? What are the allegations and so on? Lisa was never removed from the entire process because he was still there after I would report to the HOD, HR. That would be a process for her to take forward. And it's consistent with the system of delegations of council in terms of our compliance function, my compliance function, HOD's function from the compliance, from the HR part. So it's consistent with that aspect in terms of compliance.
Mr. Behari, words have meaning. It says request for allegations to be investigated. It doesn't say that you review. It means that if somebody wants to investigate allegations against an employee, they must come and request from you that those allegations be investigated. So it means you must approve. They have to request. What is the purpose of a request?
Yeah, perhaps, as I said, I was not involved in the actual drafting of this document. Hence, I sought clarity from the HOD HR afterwards. Because where the party comes from, it's then a prima facie case. That is where that's determined at the department itself after doing the investigations. Where we come to aspects say, but when I'm finding a document, is there further investigation required? Is there internal processes or external processes? That is where the documents I've been dealing with up to now, after this thing came up. So I don't go and give allegations. I don't deal with that. The things are dealt with at the departments. If they come and say to me, it comes from the HOD to say, we want to proceed with this, I'll look at that and say, please proceed urgently. Those are some of the forms, but it's part of it. But the HOD already is involved in that processing of that. I will look at the evidence and then I will deal with the issue.
Okay. Now, as the head of corporate legal, is there communication in writing from you to clarify this position, or is there an addendum to this director from the city manager clarifying that we are not saying that if you want to investigate an employee, you must come and get permission from Mr. Behari? That's not what we're saying. No. Mr. Behari will simply oversee the process and make sure that a proper investigation is being undertaken. Where's that communication to somebody like Mr. Ngiza, who, by the way, you will recall, he sent a very comprehensive memorandum in response to this report. And what did you respond to? Because for you, this doesn't reflect the actual position or your understanding of what would happen. So where is your response to this?
My response is that there's no written memo between me and the city manager, and I engaged with my colleague, being the HOD HR. There are instances when the item comes through, it comes through into a format of a set document. I would look at the evidence that's there and what is required for. There were instances when EMPD was sending through to me, even recently, we want a further urgent investigation. But the chief or the head of that will say, proceed with the investigation. And then it comes to me as an advocate to say, what else is required? Those are documents I've been signing. So there is no formal memo, written memo, but there is discussions between us senior managers to say that, but practically, how would that impact? In the end, the prima facie case referral is to the HOD of that department.
Did that discussion of senior managers include Mr. Ngiza?
I don't deal with Mr. Ngiza. It's a discussion that should have been done between him and the HOD of the department. He knows who's dealing with what aspects, who's delegated with what functions. He is the divisional head employee relations. He should have been consulted in terms of what are the aspects. I will do that too when I'm dealing with my divisional heads in terms of how we carry out the other part.
Okay, then if you look at B, appointment of presiding officers and employer representatives to run a disciplinary hearing for more serious offences. That is delegated to the HOD Human Resources after consultation with the accounting officer, Dr. Mashazi. The authority shall be exercised upon receipt of the investigation report with recommendations from the persons listed in A. Where is Mr. Ngiza in that process?
The appointment of presiding officers is nowhere, it has never been, Chair, and that is one of the issues is the appointment of presiding officers, which is a delegated function in terms of the HOD, HR, she's responsible for disciplining across the board. The city manager has the overall delegation, and hence it was crafted in this way. Mr. Ngiza would have been taking up from either a sub-delegation from the HOD or on the directive of the HOD to say proceed with this or not. But he's not specifically here dealing with this issue. And it depends on, Mr. Ngiza is not in the directly listed in the system of delegations, October 2017.
Mr. Behari, just on those two that we've dealt with, can you put yourself in the position of Mr. Ngiza, who was really the overseer of the first disciplinary proceedings against Mr. Mkwanazi, against Brigadier Mkwanazi, that started in February 2023, which comes off the back of a Jeff Wicks article, correct?
That's correct.
Jeff Wicks seems to be a trigger for this as well, because we're talking about the anonymous email. He receives this. How is he supposed to perceive this? He's being excluded from the process. How can he not see it as an attempt to again try and protect Mr. Brigadier Mkwanazi by excluding him?
I've looked at the cumulative factors that came and led to this. Mr. Ngiza, and he's done a long letter. I've looked at the contents of the letter. Mr. Ngiza was not excluded in the process in any way. It's included. He has been the functions which are legally detailed to the HOD was reinstated to the HOD. Mr. Ngiza has been acting so far on delegations which I've discussed was ought not to have been given in that manner. But nonetheless, it was a return to the delegation functions as per the Systems Act delegations. So yes, you may believe that, but because if what has been created here totally, and for where I'm dealing with one of the issues, is that narrative to say that I'm part of the Julius Mkwanazi clan or clique, but if it's going to be using this as well, then I'm saying that there were some things that took place before that. It starts off with the huge complaint by EMPD, and that is where Mr. Ngiza was also referenced by certain officers as being part of a clique. And that is where you're talking about city managers and addressing it to say, no, we need credible, we need consistent, or we need processes, which we're not putting the HR space and our legal processes at risk. So if he believes that for me, it's something reverting to the original legal position in the city, and then he still has a relationship as an employee relations he gets from the HOD HR in any event.
But where's his due process? Because you are accusing him of certain allegations which, according to you, culminates as part of the reason why this directive is being issued. He doesn't get engaged as to why are the costs so high? Why are we losing so many cases? He's not involved in that process. He wakes up to a directive that says on page 313 of that document, all that you are going to do now as the divisional head is under I. And that is handling of step 3 of the grievance procedure. All step 3 grievances should be submitted to the office of the HOD for coordination through my office, and inquiring a register is kept. Persons responsible, the head of department, human resource management and development, the divisional head, employee relations. On all the steps taken in the disciplinary process, he's only delegated that. How is that possible for a senior person, an HR specialist, to be minimized to only deal with grievances, and you want to suggest that it had nothing to do with a trigger event, being the anonymous email?
From our side, this culminated from the reports of the EMPD officers calling for a meeting. Because if that was the case, if the problems was as at proceeding with the matter as at May, June, that would have been addressed at that stage. If it was removing functions from him because of that incident, this matter here came through. There was a trigger off, which I could see was from the 17th of August. There was no functions given to the city manager by the city manager to anybody which were not contained in the system of delegations. So it was a reversion to the authorized system of delegations, which I maintain. Mr. Nisa had no such powers in the first place. As the divisional head, everything reverts to, in terms of the process in the HR department, to the HOD, generally in terms of, unless he's received a special delegation where his name is listed for a function. If the city manager had taken that away from him, then that would have been illegal.
Okay, so your evidence when you said that you don't decide whether to go ahead with disciplinary proceedings, remember that was in the context of you saying that it was just an added step of compliance. And I asked you, so if there's tension between what the HOD wants to do and what you ultimately come to a conclusion should be done, you said you don't get to decide that. But if you look at what it says about the investigation, it does suggest that you decide whether allegations will even be investigated. In other words, you get to decide whether disciplinary proceedings are even triggered.
And I'm saying that the discussions then between myself and HOD, that is why HODs up to now come and they do the investigations. I have 3 columns that I look at in terms of that. Is there further investigations required to complete and ensure that we are covering ourselves on all bases? Or can it be something of a nature that we can proceed immediately with an internal disciplinary process? Or do we need to go for a tribunal? Looking at that aspect documents, I then recommend to the HOD to say, yes, I believe that there should be further investigation and so on. I do not decide on whether it's going to go ahead or not.
Can I just check this? That paragraph 8.2 that you're discussing now, where requests for investigations must be submitted to you. This new arrangement is in August 2023, and then IPED report is in September.
It's signed September, but served in the city in November.
Okay, I think it doesn't matter. The point is it's after this new arrangement in place. So you would have been, according to A2, you would have been the one to authorize an investigation before disciplinary action was instituted against Brigadier Mkhwanazi, if there was compliance with the IPED directive. How would it?
I just want to, do you mean to institute disciplinary action?
Well, A2 says, requests for allegations to be investigated must be submitted to you for you to confirm the allegations, consider the evidentiary material, and submit a report to the HOD. So what I'm checking with you is, according to this A2, if there had been implementation of the IPID report, which was still outstanding at that time, right? The city manager knew that IPID was conducting an investigation. That's according to the evidence before us. I don't know what you knew at the time, but you would have, this A2 would have landed you on your desk with whatever material was going to be presented at the disciplinary hearing for you to confirm the allegations, to consider the evidentiary material, and then to submit a report to Human Resources.
No, it's not in external regulatory bodies. IPID is a law enforcement agency, similar to the SRU, similar to Public Protector, and so on. Those reports, when they come through, we have the option to consider. I consider all the reports, and then we decide what is the next route. Do we go and review? Do we address them for further to get more information? And that has been happening, the process.
No.
This was for the internal processes.
Okay. Let's take out the review of the IPID report, because we know you did not do that. And we know the MMC, you drafted a letter where the MMC, in fact, forget the letter, you say the MMC said to you that the report must be implemented, right? So we are at a point where there's supposed to be disciplinary action, because that is what is directed should happen. And the MMC has said that must happen. You must implement that report. So what I'm checking with you is A2. In terms of A2, you would have been the one that looks at the allegations for disciplinary charges. So someone would have had to prepare a charge sheet, because this is now in place by the time you get the IPID report.
Okay, this process laid out here is for all internal matters. IPID matter, being an external matter with a directive and recommendation and so on, would go, and MMC said implement, it would then go to the functioning, being the head of department and the HR department, to continue with that. We looked at as to say that what are the legal ramifications or concerns that we could have, and then, but it's unrelated to this document.
So you're saying Chief Mapieye would have been entitled with Mr. Ngwiza to carry on and get whatever necessary approvals from Mr. Kasheka, and you would not be reviewing the evidentiary material?
Not for the external part. We looked at the review or not even a review, to look at what are the challenges that we could have, but that's from a different compliance perspective. It doesn't impact upon that issue or the process of Chief Mapieye.
So you would not have become involved in the disciplinary action. That's what you're saying.
No.
This was not going to apply to the IPID's directive.
It would not, yes.
Okay, thank you. Thanks, Ms. Nair.
Thank you, Commissioner Baloyi. Can we then go to page 30 of Mr. Ngwiza's statement, which deals with the second anonymous email? And paragraph 98 of his statement.
Yes, thank you. I have it.
He then says, on 2 September 2023, a further email was received from Kiki. This email was longer than the first one and went into some detail implicating of Dr. Mashazi in shielding Brigadier Mkwanazi from his disciplinary proceedings. Vicky even mentioned that my powers to do my work had been restricted in order to protect Brigadier Mkwanazi, and he then attaches it. He then says, on the 7th of September 2023, so 5 days later, I was served with a pre-suspension letter and suspended soon thereafter. What was your involvement in his pre-suspension in light of the new directive that had been issued on the 22nd of August 2023?
Okay, on his pre-suspension letter, there was a complaint that came through from Mexu. That was a criminal complaint lodged by Mexu to the police. It was being investigated by Detective Sergeant Madubani.
You say it was a complaint from?
From Mexu. Mexu is it's a union minority union in the city of Ekurhuleni, where they raised a criminal complaint on fraud in terms of his qualifications. The police officer was investigating the matter. He came and saw the HOD HR. I was called into the meeting because when it comes to police officers and dealing with them, I come to see what is actually needed. There was a subpoena issued, and we proceeded there. Then that pre-suspension was as a result of that. I didn't involve myself in that pre-suspension letter that would have been created by the HOD HR.
But would there have been a decision prior to the issuing of the suspension letter that the allegations must be investigated? There would have been a request for these allegations to be investigated that resulted in the pre-suspension, which is now within your domain because the request must come to you.
There was already a police investigation. There was a criminal case that was opened. Those were already being investigated by the police officer. In the course of that, the HOD then requested for verification.
Let us adjourn, will indicate when we come back. Sorry for stopping you mid-sentence.